Request the speakers of the day, Ms. Tanya Baranwal and Mr. S. Badrinarayan, please come on the stage and take their seats. Ms. Tanya Baranwal heads the Kolkata office of India Law LLP and specializes in litigation with a strong focus on insolvency and bankruptcy, corporate and commercial laws, arbitration, securitization, RERA, and consumer matters. She has successfully represented a wide range of clients, including corporate entities, promoters, nationalized banks, resolution professionals, and applicants before the NCLT and Appellate Tribunal in high-value IBC cases. Her practice also extends to RERA and REIT, where she appears for builders as well as home buyers. With a proven track record in handling complex litigations before civil court tribunals, appellate bodies, and high court, she is recognized for her expertise in litigation strategy, drafting, and effective advocacy. In addition, she actively engages in commercial arbitration and advisory work, particularly in the area of insolvency laws, delivering strategic and result-oriented solutions across diverse legal domains. At a personal level, I have heard Tanya and she's too good, and I hope you will also enjoy the session. I would now like to invite EIRC Chairman, past EIRC Chairperson Sonu Jain, to please come and felicitate for this session is CA S. Badrinarayan. CA S. Badrinarayan is a qualified chartered accountant, company secretary and lawyer with a master's in commerce and a law degree from the University of Delhi. He has also completed certifications in forensic accounting and fraud detection, sustainability reporting, and French language. With a significant expertise in the IBC, he has advised on corporate insolvency resolutions, liquidation processes, transaction reviews, resolution plans, and one-time settlements for companies with large debt exposure. His industry experience spans sectors such as steel, thermal, and gas-based power and EPC contracting. A regular contributor to reputed journals including ICAI, ICSI, and International Corporate Rescue, he also serves as guest faculty at institutions like ICAI, IBF, NISM, and ICSI IIP. He is currently a special invitee to ICAI's Insolvency and Valuation Standards Board 2526, a key contributor to the Resolve Convention and part of the INSOL International Future Leader Program 2425 and INSOL India's Young Practitioners Committee. I would like to invite IP Pankaj Tibrewalji to please come forward and present a memento to CAS Badrinarayan. So together, they will help us explore not just the challenges, but also the opportunities and learnings that personal insolvency offers in strengthening the IBC ecosystem. I encourage you all to actively engage, reflect, and take away practical lessons that can enrich your own professional journeys. With that, let us now invite our first speaker, Ms. Tanya Baranwal, to address the gathering. Thank you.
So what happens when the burden of a company debts follows you home? Into your personal life, your family, your savings, and sometimes even your future. That is the reality we are beginning to confront with the personal insolvency framework under the Insolvency and Bankruptcy Code. For those who may not know me, I am Tanya Baranwal, Associate Partner at India Law LLP, and I am delighted to be speaking today on a subject that is both timely and deeply consequential, personal insolvency under the IBC Code. And our today's topic is challenges and learnings. While the code first made headlines for transforming corporate insolvency, we are now witnessing the strong emergence of its personal insolvency regime, particularly in relation to personal guarantors to corporate debtors. So today, let's look at where we stand with personal insolvency, what the courts are saying, and how it comes out in practice, and what it really means for the people behind those cases. In the end, personal insolvency isn't just about law and finance, it's about people, choices, and second chances that is there. And that's exactly what we are here to reflect upon. So, understanding personal insolvency practice in India. Personal insolvency under the IBC applies to individuals, including guarantors, who are unable to repay their debts. Part 3 of IBC introduced a detailed framework for personal insolvency and bankruptcy, providing the clear procedure for initiating insolvency by or against the individuals. This formalizes and strengthens the practice of personal insolvency in India, establishes legal certainty, efficiency, and fairness, and enhances the insolvency regime by bringing individuals and firms under one unified law. In the boardrooms of India's corporate landscape, a seemingly routine document often gets signed with a fanfare, the personal guarantee. What appears to be a standard formality and in securing corporate loans has become one of the most important legal instruments for both promoters and the creditors under the Insolvency and Bankruptcy Code. The liability of the PG, as held by in a catena of judgments by the Honorable Supreme Court, is always a coextensive liability. If the money is recovered from one PG, then FC can't go against another PG. If not, then the insolvency resolution process can be filed against all the PG of the CDs, as they share a coextensive liability along with the CD. So we all know that there is a proper procedure that we have to follow for personal insolvency. I won't go much into that details because there are other challenges that we have been facing in the court and during the process. So one of the most important issue that we have been facing in the court is what is invocation and the limitation point. So limitation. So now, whether, as held by Supreme Court, there are many judgments which says that there is an acknowledgement of debt, so that extends the limitation period. Definitely, that is there. What about the OTS letters? Because many PGs are coming and saying that no, it cannot be, because they were not in the knowledge, they didn't have the knowledge that there is an OTS letter. But if a managing director or a director who has signed the balance sheet or is there, he cannot take that plea, that the OTS letter cannot be considered while extending the limitation period. Second is recovery certificate. So whenever there is a DRT proceedings, because we are doing a lot of bank matters, so we see that almost all the banks do take care of the debts. They do go against the corporate debtors, including the personal guarantors, before DRT under RDDB Act now. So now whenever there is a recovery certificate, because we have seen that there are cases which are of 2002 and 2014, so when the PGs are not entering appearances, so if the bankers have not initiated personal insolvency, they are barred by limitation. So whenever a recovery certificate is issued by the DRT, so that gives a new life for the limitation to the bankers to proceed against the personal guarantors. So this we are advising all the banks, and that's what Supreme Court has held also in a catena of judgments, and this applies not only to personal guarantors but to the corporate debtors as well. Another interesting point is whether 13.2 can be considered as an invocation for the personal guarantee. So this is a very important question because we have been fighting for the bankers, and we are seeing that now the bankers have started invoking the personal guarantees, but before that we have always seen that 13.2 has been issued, and they do not, in very less cases I have seen that the bankers are issuing another 30, apart from 13.2 they are invoking personal guarantees. So NCLAT has also held that if there is a specific demand from the personal guarantor in the 13.2 notice, then still it can be held as invocation, which I have been trying to explain to a lot of NCLTs also, because they are saying no, NCLAT has said that 13.2 notice is there, and so it cannot be considered as invocation. But NCLAT has specifically held that there has to be a specific demand from the personal guarantor. Even if it is a 13.2, they will definitely accept it, but there has to be a specific demand from that personal guarantor itself. So NCLAT has clarified that a demand notice under section 13.2 can effectively invoke a personal guarantee provided it explicitly demand payment from the guarantor. So now, plus there is acknowledgement of liability, whether in a balance sheet or in a by way of balance confirmation. These are considered as limitation. These will cover limitation points. So what we are seeing the challenges is posed for the personal guarantors as well, that there is a lack of awareness about the personal insolvency provisions amongst the individuals, which is one of the very important reasons that they are not able to move forward, or they are not able to do certain things. For example, there are certain excluded assets also which they have to take care of. Yeah. So there are certain assets which is termed as excluded assets of the personal guarantors, and that cannot be included while finalizing a repayment plan. So those are the personal assets, domestic needs, unencumbered life insurance policy or pension plan, and ornaments. So any personal ornaments belonging to the personal guarantors of value as prescribed, then in such cases exemption is up to 1 lakh rupees for ornaments only. And what are personal assets? Personal assets are those that are required to do living, that plays an essential role for living, including books, vehicles, any other equipment not necessary for the purpose of employment of PG. So in that way, I would say that lawyers and CAs, we have a lot of books. So we are at least, we are at least safeguarded. Then there is unencumbered life insurance policy or pension plan. So if the PG transfers or invests funds in life insurance, that won't be included in the repayment plan. So that also is a very helpful thing for the PGs also to consider. In such cases, there is no limit to transfer to life insurance policy imposed on a personal guarantor. Then for unencumbered single dwelling unit, and when insolvency process is initiated against the personal guarantor, the property is excluded where you live or stay, and the property must be worth 10 lakhs rupees for property situated in rural area and 20 lakhs for property situated in urban area. Yeah. So in cases related to Sridhan, because there are personal guarantors by mothers, by wives of the managing directors. So what happened in cases of related to Sridhan? So there is no provision under the code itself, but status of Sridhan in various parts of the country is defined separately. Permission is definitely there, is required, I would say, to sell Sridhan, and Supreme Court has specified that it cannot be used as an encumbrance. It is essential to determine the source of Sridhan, which can be from father, husband, or even be ancestral in nature, as well as marital status of women plays an essential role, that is married, unmarried, or separated. And lastly, the thought of selling Sridhan differs from school to school. That is Mitakshar, where gifts given to the wife cannot be disposed without the permission of the husband, and Dayabhaga, where gift given to the wife cannot be disposed without the permission of the father of the woman. So I have seen, like whenever there was a recovery proceeding before the DRT, we have seen that the personal guarantors do take this plea of Sridhan, that so many amount of money, that is the Sridhan, and the courts cannot attach those until and unless there is a permission to attach. One of the most challenging situations that we are facing day in and day out is that DRTs and NCLTs are burdened with significant case loads, effective timely resolution of personal insolvency cases, as we see that it is always at the end of the board and it never reaches. So some of the personal guarantors who are willing to give a repayment plan also, because there's always a stigma involved, comes along with it. So whenever the repayment plan is giving, definitely, unlike CIRP process, there is no prescribed format while submitting the repayment plan. It is upon the PG to sit with the resolution professional and draft a repayment plan and prepare a repayment plan, so that can be presented before the creditors for their voting. So what is the way forward? When a corporate debtor takes a loan that is guaranteed by another company or an individual, in case of default, the lender can pursue the debtor as well as the guarantor. To simplify, the IBC ensures that if insolvency proceedings are ongoing against a corporate debtor, any insolvency proceedings can be proceeded against the personal guarantors as well, and before the same tribunal as held by Supreme Court, ensuring a coordinated resolution. Under the IBC, personal insolvency for individuals, partnership firms, and proprietorship is being implemented gradually. Now, personal guarantors to corporate debtors now have a clear legal framework to initiate insolvency and bankruptcy proceedings, and the process is regulated through rules and regulations notified in 2019. Personal insolvency strikes a balance between debt relief for individuals and recovery rights for creditors, including clear definition of assets and income to determine eligibility for resolution, structured repayment plans that are fair, transparent, and prevent exploitation, a systematic approach for loan waivers, ensuring orderly discharge of qualifying debts, integrating discharge and repayment information with credit bureau to reduce moral hazard and help creditors make decisions. To conclude, personal insolvency practice in India under the regulations of the personal guarantors to corporate debtors strengthens the framework, providing clarity, proper procedure, and legal protection. While challenges like limited awareness and procedural delay exist, the IBC has modernized personal insolvency in India, giving debtors, especially the personal guarantors to the corporate debtors, to resolve debts, rebuild their financial lives, and promote responsible lending and borrowing. The personal insolvency framework under the IBC is a step forward in creating a fair, efficient for debt resolution in India. Thank you so much. So this is the end of the session, and I would like to have Rashmi come in. Thank you so much, Rashmi.
So if we have any questions on personal guarantor, yes, please. We can take 2 to 3 sessions and then we can move forward to another session. Okay, fine. So we can take the questions at the end of the first technical session. And I'll now invite Mr. Badrinarayan to take his session, please.
Slides. Oh, this is not mine. Slide has to change, no? टेक टीम है आपका? मेरा स्लाइड हो गया, डेट लिखा होगा मेरा। ये वाला थैंक यू। A very good morning, everyone. At the outset, I'd like to thank EIRC for organizing this. I was, for the last conference also, I was there, and fantastic efforts by the EIRC team. And very good morning to the dignitaries on stage, off stage as well. And to keep the introduction short, I like to start from where Tanya ma'am left. And I'll also like to connect to what she was speaking on. So we had 2 judgments which laid the foundations for personal guarantees. One is Lalit Kumar Jain judgment, which kind of upheld the constitutionality of the notification which came in 2019. And one is Dilip Jeevrajka judgment, where the question of audi alteram partem, which means the right to be heard, was contested. The personal guarantors were saying that, RP files a report, gets admitted. We are not heard when RP files a report. So at that stage, whether the principles of audi alteram partem is there or not, that was contested. And that was also upheld. Honorable Supreme Court said that the code is fine, the provisions are fine. And anyways, RP is doing a facilitative role. He's just taking information, collating and giving it to the NCLT, and then NCLT is adjudicating. So you can always raise your questions before NCLT. So these 2 judgments has laid down the jurisdiction for personal guarantees. In fact, because we did not have that foundation, there was lot of gap. From 2019 to, you can say, 2022-23, it has taken for cases to start getting admitted, because a lot of NCLTs were not admitting cases, adjourning it. Some NCLTs admitting it, but it's not going forward. My topic actually is bankruptcy, which happens even after personal insolvency is finished, which takes 180 days. So bankruptcy is even newer. You don't have more clarity or judicial precedent or guidelines, and the regulations came in 2019. The regulations have not gone through the practical implications. Only when you put something to test, only when you practically implement it, you get to know what the economic challenges are, what the gray areas are, how it's being, I can say, gamed by various stakeholders, and how to, fix those loopholes. So we have not had those opportunities. The jurisdiction is evolving, the jurisprudence is also evolving for bankruptcy. Again, touching upon a couple of points on invocation of guarantee. So I've been handling personal guarantee cases, bankruptcy cases as well. Fortunate to get some bankruptcy cases in Hyderabad. Now, invocation becomes a very big pain point. Why? There are a couple of defenses which the guarantor will use to get away from personal guarantee cases, and most of them will be procedural. So, there have been judgments like ma'am said that SARFAESI section 13(2) notice is not an invocation, and this created again a lot of confusion. If a bank is sending notice and demanding money from those who are liable to pay by guarantee or whatever means, that should satisfy it. And when the debt is being acknowledged in the balance sheet, when the corporate debtor is being driven through CRP, when there have been OTS settlements, there have been acknowledgement in various letters, then insisting on a particular kind of notice may not serve the purpose. What's happening is you file a personal guarantee case for, you file an application move a personal guarantee case, interim moratorium sets off, but by the time it takes admitted, all these procedural lags, delays a lot of stuff. And in interim moratorium definition, if you read, it says creditor should not take any action. And like we all love to, interpret in our own convenience. So the guarantor is taking action on the assets. He is playing left and right with his assets. He is doing sale. He is gifting it off to his children or grandson. He is just doing avoidance transaction. So that issue has to be, somewhere sorted out. So when a bank invokes by a demand notice, recall letter or a SARFAESI, that should kind of be an invocation for guarantor as well. And again, very recently the judgment came on that, which clarified that it depends on the wordings of the notice. If the wording is calling specifically on a particular person or guarantor to pay up, that satisfies the requirement, which makes good logical sense. We also had a judgment, I think yesterday or day before, from Honorable NCLAT on invocation for corporate guarantee to come as a claim. Not connected to the session, but again it was important because there was one Arun Kumar judgment of NCLAT where it was said if a CRP has started against a corporate guarantor company, but any claimant who has not invoked corporate guarantee cannot file a claim because he has not invoked, it doesn't become a debt. And then in CRP he cannot invoke the guarantee because there is a moratorium. You are making somebody lose his right to recourse. How does he, even go against the guarantor? We say Section 128 Contracts Act makes coextensive liability between guarantor and the principal borrower. But by saying that you can't invoke during CRP and before CRP you have not invoked, so now you can't file a claim. So you are somewhere stopping his legal right and legal recourse. Now a judgment has come. We had a China Development Bank judgment from Honorable Supreme Court, which was not noted in the Arun Kumar NCLAT judgment. Now recently, yesterday, day before, a judgment has come where NCLAT has took note of that judgment, referred to the Arun Kumar judgment and said that even if pre-CARP invocation has not been done, that is also fine because the definition of claim is satisfied. It can be matured, it can be unmatured, includes invoked and uninvoked also. So we are having all these evolvements, which is fine-tuning the code, fine-tuning the way how guarantees work. There are multiple judgments on the guarantor's liability. You can even go behind the guarantor first and not necessarily to go behind the principal borrower first. And there is also a lot of judgments on thresholds now. So it's very clear from NCLT and NCLAT judgments that the threshold for personal guarantee cases will be 1 crore. It won't be 1 lakh. Again, a lot of personal guarantors were creating this issue that the threshold is less and this should not have been admitted. These things are also being clarified. Now coming on to excluded debt and excluded asset, which is a very interesting point that will apply for bankruptcy also. There was a judgment from Honorable Supreme Court on Sarangak Anil Kumar Agarwal, which basically said that moratorium under Section 96, which is there for personal guarantor, that will not cover regulatory penalties. So in that case, there was a Consumer Protection Act penalty levied and the moratorium was said not to cover that. But in that same case, the Honorable Supreme Court noted that Section 14 is much broader. So Section 14 in a CRP is much broader than Section 96 in personal guarantee. And see, if there is an environmental harm done, if there is an environmental penalty levied, and you come under IBC, you go under moratorium, and you say it's not payable by me, doesn't make sense. If, in fact, going forward, probably environmental consequences will be treated very similar to criminal consequences. You are impacting an entire society, you are impacting an entire set of stakeholders, the future generation who is going to live in that environment. Then we come on excluded asset. Now this is used a lot to ring fence the asset. Like again, ma'am said, Stridan. Okay, so in personal guarantors, what happens is on a basis of repo or face value of a promoter, at the time when things are good, banks may not do that strict KYC, may not do. Some banks are having very strict protocols, and sometimes the promoters are also not very fairly representative of their actual positions. They may give a net worth statement certified by somebody, and quarterly or yearly they should have to give an updated statement as well to the banks. Now what happens? That time they would have very good credentials, personal guarantee would be issued, and the bank of it, loans would have been given with some other collaterals also. But with time, when the company for which they gave guarantee faces insolvency proceeding, it's going to have a cascading effect. The guarantor knows that. He is going to start ring fencing his assets as well. He is obviously going to protect his assets as well. Now, in the net worth statement, he may have showed cash, gold, some land, some partnership interest. All these things come, right? Cash, you can't find out. He will say he expended it. Gold, he will say, things were tough. He sold gold and he used it for his expenses. He may also say that the gold had to be given in Sridhan, like one of the example was there in the excluded asset definition also. You can't get those things back. In fact, we are having cases where divorces are being staged just to show as if the husband and wife are separated. Husband is the guarantor, he is bankrupt, all the assets are transferred to the wife in some way, and they stage a divorce. So these days, it's the social taboo in that segment, at least, it's not happening. People are happy to do that. And you also have avoidance transactions happening where assets are being transferred to grandchildren and distant relatives, and not even the lenders are not also even aware as to when the transaction happened. So just wanted to set the context on what was it. Now I'll quickly go through the challenges slides. So this includes everything on personal guarantee. So I'll not go into the sections for the insolvency resolution of personal guarantors. I'll want to go into the bankruptcy straight away. Yeah, so in a bankruptcy process, probably process will be aware by all here, but just to give a broad snapshot, once personal insolvency resolution fails, just like in a company you have CARP and then you have liquidation, once personal guarantor insolvency fails, you have personal bankruptcy. So for that, an application is filed before Honorable NCLT, a bankruptcy trustee is nominated, and coincidentally, here also you have a COC, Committee of Creditors. You don't have that in liquidation, although now they are suggesting instead of SCC there should be a COC. But as the code stands, you have COC in CRP and you have COC in bankruptcy. So a bankruptcy trustee is nominated. When the application is filed, there is an interim moratorium given, which is very similar to Section 96. And when the NCLT orders bankruptcy, on that date the insolvency professional is appointed, and all the assets of the guarantor will then vest in the bankruptcy trustee. Then he has to give a public notice, he has to give a notice to the creditors to file claims, he will prepare a list of creditors. Again, you will have secured creditors, unsecured creditors, you will have to go through the security package. Now here, you have to make it analogous to the liquidation proceedings, because here also you are taking custody control of the assets for the purpose of, realizing it, selling it, and distributing the proceeds to the creditors. And you have a similar section to Section 53 here as well. So vesting becomes very important. And I don't think you'll find a lot of if you do Control F and find on the code, you will not have this vesting word too much, and it will be there in the bankruptcy provisions. So creditors will register their claims, secured, unsecured split will be done. Becomes very important because the rights of secured, unsecured are different. Then preparation of list of creditors, then notice is given to summon committee of creditors. Main job is to identify bankruptcy estate like you do for liquidation estate. So I have to find out this guarantor, how many assets he has, where all he has. Becomes very tough, because we are lagging a database right now. It's not like you can go into some website, put a PAN card detail or Aadhaar detail and get a list of assets. We are moving towards a system, but it is yet to come. So you will have to use a lot of different interfaces to, get those kind of details. You will have to do Search search. It's kind of like very cheap, 5 rupees, 10 rupees. There are 3 classes of asset. Tangible, intangible, just put the PAN number there and do a search. If they have registered a mortgage in CERSI, you will find along with the bank name. Then you can write to the bank obviously to get more details. By doing this simple step, we are able to find good high value properties. Because a lot of times what happens, existing lenders in the corporate debtor, they obviously will not be aware what the personal guarantor may be doing in his personal life, right? In fact, even if personal guarantor has existing loans, even those lenders are not being told if a new asset is being bought by the personal guarantor. In fact, to go a step further, if an asset is bought and that asset is mortgaged by the guarantor with a loan with a bank for a loan, that bank is not even being told when that asset is being transferred or gifted to somebody else. This is a practical example which we are facing in a bankruptcy proceeding. And first of all, the bank did not know that the proceedings are there. So we approached them, we did a search, we approached them, we said, you have to file a claim. When they were evaluating for filing a claim, they wrote to us saying that, see, these guarantors took a loan from in 2017. And 2019, we understand that they've transferred the asset and they've not taken NOC from us. And the process has started in 2024 or 25. So 5 years, the banker did not know that the asset on which collateral was created has been transferred to somebody else's name. That is the status which is there. And the bank is getting a EMI, so they are quite happy. It's a standard account. Even now, 21 lakh rupees per month EMI is coming. Nobody knows where it's coming from. The guarantors are under the process. All the guarantors are under bankruptcy process, but somebody is paying the EMI. And when you ask that particular financial institution, where is the tracing of this money? They are basically saying, I only get it from RTGS, we don't know. Then the bankruptcy trustee has to obviously say there are PMLA provisions as well, boss. You can't just receive money from a random account. That will be a violation of all money laundering accounts. So now again, you have to coordinate with the guarantor who will be absconding, who will not be replying, not responding, because they are not taking it very seriously. You have to coordinate with all the creditors. You will have to find creditors. This one personal guarantor may have issued guarantee to multiple companies. One of those companies may have gone into insolvency. What about other companies? You'll have parallel claims. And I believe, personal view, if we read the BLRC report also, ILC reports which came on guarantors, there were 2 working group reports. The intent is to rehabilitate the guarantor back into the system. We don't intend to have parallel bankruptcy proceeding like we have in US. We want one shot that everybody files a claim against this gentleman, because asset pool is one. A guarantor is going to have one asset pool. So everybody who has any dues file a claim and, as per the process, get it distributed, and that should be the end of it. The gentleman or, the guarantor should be, rehabilitated into the society and be able to live a normal life. So these, again, I'm just building in some challenges in between itself. So main role, identify asset, sell those assets, realize money, and distribute the money. Then he has to file a report saying that I've administered, completed the bankruptcy proceeding, and then there will be a discharge under section 138. So these are just some provisions. 124 as interim moratorium, 129 as vesting, and disqualifications of bankrupt. They can't travel abroad without permission of Honorable NCLT. They can't hold public offices. So a lot of disqualifications have been given for them. Rights and functions of bankruptcy trustee. Bankruptcy trustee can act on behalf of the bankrupt, and he can take all actions which are required for the protection and preservation of the assets. And then you have the concept of dividend here. So you can give an interim dividend if you have made some sale in between, or you can give a final dividend. And like section 53, you have section 178 also, which decides the order of priority of payment. Yeah. So now challenges. Lot of challenges, because it's new. I'll not say challenges. I'll say practical issues which have to be handled, and which we as professionals will have to find ways to handle, and also the judicial precedents which will come in this area once the issues reach the courts, it will give more clarity. One is lack of cooperation from the bankrupt. Okay. When an application is filed by a bank to initiate personal insolvency resolution, and then even on bankruptcy they have to file application, there are a lot of fields which have to be filled up, including the details of excluded asset, excluded debt. Most of the application you will see will not have that, because that information is not there. And that information is not coming from the guarantor also. What is the way to get these information? What is the way to get the information on assets of a guarantor? The best way is, if the company is under CRP, and the promoter is also interested in giving a plan, you can always ask him all information about his financial net worth, whichever groups he want to trust on, depend on, and he will have some motivation to give those information. And then that can be used. So we will have to have a lot of foresight. We can't wait for the day that the guarantor goes into insolvency, then I'll write him a letter and get information from him. What's happening is, they don't respond. They will get some doctor certificate saying, I've got amnesia, I've got dementia, my parents are not able to, sign anything properly. You can't verify those things, and there is a humanitarian angle also here. You can't really intrude into somebody's privacy like that. But then you find out after investigation that the same person with amnesia has written off a gift deed transferring the asset 1 year back. So all these things corroboratively have to be looked at to get some recovery for the lenders. Then there is non-compliance. Non-cooperation, there is a provision, regulation 12 under bankruptcy regulation, very similar to section 19, where you can approach honorable NCLT, take a direction. What after that? You get a direction, still they don't respond. The best way we found right now is to straight away go and file a contempt petition under Contempt of Court Act, which again is not very effective, I'll say, because under Contempt of Court Act, if it's a civil contempt, you go and apologize, the court will dismiss it. All that you have to do, and very small jail term, very small penalty, and an apology is going to dismiss the case. So he may not come for 3 hearings, he will come for the 4th hearing, he will say, I'm sorry my lord, I'll cooperate, and then he will again start non-cooperation. Then we also have bankruptcy estate issues. We are not able to identify which assets are there for the bankrupt personal guarantor, because the banks may not have information, the guarantor may not be coordinating. For this, there are agencies which are now there, which have proprietary land records. You give an engagement to them, they will find out all the lands in the name of the guarantor. But the problem is, the assets may not be in the name of the guarantors. It may have been ring-fenced, siphoned off, diverted somewhere else. So that problem will, make you unable to, determine the bankruptcy estate. Also, we can do a lot of stuff like CERSAI search. We can try and find any old net worth statements. You will have dividends there. If possible, we can write or get an order against income tax department, get 26 years, we can see what dividend, what interest is coming from there. So these are again some practical things which we do to find out asset. We also reach out to sub-registrar's office, revenue records office. So you study the lifestyle of the guarantor. The guarantor stays in a place, the company is running in a place, definitely they will have assets around that place at least. So you go to the sub-registrar office there, revenue records office there, you give the details. In fact, you give the list of names of the entire family members, and then you ask the registrar to do a search and give it to you. And that also gets you a lot of assets sometime. The results is actually surprising. You don't have to appoint any agency for it. Certain things can be done by the IPs itself, by the chartered accountants itself, and it's very simple. Some things are online as well. Then security enforcement. There is a provision in liquidation also, same is there in bankruptcy also. If a creditor says, I am a secured creditor, I want to enforce it, I don't want to relinquish it, there should be a timeline by which he does that, right? So here what happens is, the creditor will say, I have a mortgage, exclusive one, I am going to enforce it, I don't want to be in your bankruptcy proceeding scheme. But if he doesn't do it within time, the process is 1 year. He takes 6 months, 9 months to take any action against the guarantor because he is getting his EMIs. Then that is a dent on my bankruptcy estate, because suppose his debt is 10 crore, but the value of asset which he holds, he might have bought some land or property which would have shot up in 3 years. We have seen 2x, 3x rates, right? So the 10 crore property would have gone to 50 crores, and the debt, the difference is going to come to the bankruptcy estate. So if the secured creditor is not taking action to make sure the money comes back, the surplus goes back to bankruptcy estate, the other creditors are at prejudice. So that is also an issue which has to be addressed. There has to be a set timeline. And then voting right and COC. Again, I'll say a gray area. Probably I'll have to work more on this. I'm also trying to make this similar to liquidation proceedings. So bankruptcy proceeding says voting right will be given only for unsecured creditors. It won't be there for secured. In liquidation, you have stakeholder consultation committee. You don't have this problem at all. But in bankruptcy, you may have people in the COC because they filed a claim, but they enforce security interest, and the value of security interest is more than the debt outstanding to them. That's why they may not have a voting right, because they don't have any unsecured portion. Again, that's a point which can be litigated also. And when I go for seeking contribution of cost, I will of course ask this person also, who is a zero voting person, to contribute to the cost, because in liquidation proceedings, a person who exercises security interest has to contribute to the liquidation cost. So similar analogy, I'll presume, should be applied here also. But if I get a surplus, this guy has enforced security interest and he says that he will deal on his own. So I'll obviously distribute it to the other creditors who are there, because he has a security interest and he has enforced it. It's his issue that he is not doing it properly. Then lack of specialized skills. We are yet to get that ecosystem, because again the law is being put to implementation now only. So asset tracing agencies, how do you trace asset, how do you have the proper data collection for guarantors, all these challenges, practical issues are there. Now there are a lot of judgments, not going to go into them because a lot of us keep on reading judgments. Now way forward is the financial institutions, the banks, the creditors, they have to be more proactive. They have to know about key documentation, right? Invocation. It's simple, right? Why do we want to get into procedural issues? If the law says SARFAESI notice has to be issued like this, issue it. If your guarantee agreement says there's a proper format for it, do it. Why to leave any loophole there? Because these things are stretching the matters. In fact, we have personal guarantee cases where from 2014 it's an NPA. The promoter, the company, everybody declared a willful defaulter. CRP started in the company, claims of the banks have been admitted there. OTS settlement in between had happened, acknowledgement of liabilities there, everything is there. Then personal guarantee process has started. The primary issue raised by personal guarantor is that stamp duty was not adequate in the personal guarantee agreement. I mean, if these kinds of issues are going to be brought out to stretch out the thing, you will not see a resolution. So we will have to ensure that the documentation is foolproof at all times and with foresight. We can't leave it at a time, when it gets to there we will see that. Second, we will require more clarification guidelines on moratorium. What moratorium covers, what moratorium doesn't cover. Then provisions are there for cooperation from the guarantor, but we want strict implementation. I mean, what if he doesn't? So in IBC, you can't go to NCLT for as a criminal offense. You can't take NCLT does not have that power to do it doesn't have the jurisdiction. You will have to write to IBBI, and IBBI will prosecute it in a special court. That's the procedure, right? So that is there. Apart from that, you can only file contempt of court, an application with NCLT under Contempt of Court Act, which again I said it's not very effective. Then there should be direction to relevant authorities. Yeah, there should be direction to relevant authorities. So when a bankruptcy order or personal guarantee order is being passed, a direction to authorities like income tax, CDSL, NSDL, which will have mutual fund statements, right, banks, all these should be directed to give information available with them to the bankruptcy trustee or insolvency professional. That will be the first step to smoothen out things on information and achieve some information symmetry. Then we should have some extended monitoring mechanism on alienation during interim moratorium. Like I said, the provisions are worded in a manner that creditors cannot take any action, but the guarantors are taking action. So we should have some monitoring on that mischiefs being done. Then we should also track data on haircut on personal guarantee cases. I'm not aware if any such data is being maintained, but we will have to also do this. Then only we will know a comprehensive overall picture as to how much a corporate debtor took a loan, how much was made from the corporate debtor CRP, and how much was made from the personal guarantor. And then obviously clarity on invocation of PG. Now we have judgment. If it somewhere comes very clearly, linking all these judgments, that will be very good. So that's all from my end. Thanks a lot for the patient hearing. I hope I could share some useful things. Thank you. And I stuck to the time. Thanks.
Thank you, Badriji. Now we'll open the forum for questions. Yes, sir. Somebody can please give a mic to them.
Hello. Yeah, my name is Sarup Ghosh. It was a wonderful session. But my specific question is, first, what IBC says. IBC says from debtors in possession to creditors in control. That's the basic premise. But now, if you look at the PG part, the RP is merely a facilitator, that is a postmaster. He doesn't have any power. So therefore, and there is no PUFE application also, PUFE concept. So that's basically is a self-contradictory situation where the RP is drowned. So I think this is the basic challenge, that you empower the RP, and the of course the invocation of PUFE should be there. Otherwise, this is not going to be successful at all. We can keep on experimenting because IBC is experimented for how many years, how many decades, we also don't know. But this is something that in current days has to be done. Thank you.
Yeah, so I also agree with the same, because we have seen what we have seen in the Australian insolvency also, insolvency in Australia, that they trace down to the assets of the personal guarantors for 12 years and then they trace it back. So these kind of amendments need to be brought into the IB code, and only then there will be some impactful things. As Badri also said, that interim moratorium only applies to the creditors for filing the applications and not onto the assets. And plus, all the day it was notified, all the personal guarantors were very fully aware that at some point of time they will have to, will be liable for the debt of the corporate debtor. So I totally believe that PUFE needs to be there for personal guarantors as well. Yeah.
No, any other questions?
Yeah. Yes.
Ma'am, question for you.
Okay.
Myself, Prakash Joshi. Ma'am, have I understood it clearly that parallel proceedings against CD and PG are possible?
Yes.
Okay, then question is that practically how are this being handled at NCLT level? Do they get merged or they are being treated separately?
So, so they do not merge it, because yes, that is there, that they have come up with the amendments also, that the PG's RP can be the same, who is the PG or who is the RP of the CD as well. So that is there, and they if the matter is going in a particular bench, so the matters of the PG can be shifted to that bench only. So this is how they are doing, and they have also NCLT is also directing that you connect with the RP of the CD for certain informations if it is required. So they are not merging per se, but yes, they are bringing it under one umbrella, I can say. That the RP can be the same and the bench can be same. So there are no two contradictory judgments regarding the same.
So technically there can be two separate IRPs also?
Yes, definitely. There can be two different IRPs.
That's good, right, sir? That's good for the ecosystem also.
Yeah, that's true.
But I believe that, that creates all the more confusion, because if one RP's approach is different, and if the PG also wants to give a repayment plan, what I have been facing practical challenges in a few of my matters as well. So what we are seeing, there is a PG who want to give a repayment plan and the RP is accepting. However, for his wife, there is another RP. So that is creating a lot of difficulties. That's what we have been facing. So, yes.
So ideally it should be one and the same, what I presume.
Yes.
Common IRP will serve the purpose in a better way.
The RP for the CD can be different and the RP for the PGs can be different. But for all the PGs, practically when I see, one RP should be there.
Yeah. Thank you, ma'am.
Normally that is there. When you come to guarantors, banks give name of one of the RP only for handling the guarantors. Bench is obviously going to be same, because when a company is triggered for CRP, the law says the code is there, which says adjudicating authority for the guarantor will be there where the corporate debtor is being also handled. Otherwise, it becomes very cumbersome. You can't have multiple benches dealing with it. Now, your point whether CRP and PG cases can be merged, I think that will again open up some Pandora boxes, because there are some judgments which says that guarantee can also be discharged under a resolution plan. And there are also cases where the bankers may not want that. They may want it to be different. They may know that from a CRP I may not be able to recover so much, but from a guarantor he has a lot of personal assets and I want a different proceedings for that. So merging will not solve all. And then again you will have to have consolidated proceedings. It can't match the timeline. CRP is 180, 90, 330 days, and guarantors again, you will not be able to merge so many things together.
Thank you. Thanks a ton.
Thank you.
Anybody else?
Like this.
The amendment bill, I think amendment bill will take care of this, all the issues about this guarantee issues of moratorium and,
Section
you know,
14.
yeah, so everything will be taken care. I think that will be a good thing. What is your view?
I also agree, sir. I actually look forward to hearing Suman sir and also from you during this conference on the amendment. I know you took a session 2 days back also. But again, it's a bill. It has gone to select committee. It has to be passed through the process, become an act. We don't know by when that will happen. So, but I do believe Section 14 amendment which has been suggested will take care of the problem to an extent.
And even guarantors' asset can be clubbed if
It can be.
creditors agree.
Sir, if
so
all the
that will be a good,
it's good.
law.
It's
Yeah.
good. If all the creditors are same, interest is aligned, and they are agreeable, then it will make a logical sense. I mean, okay, in pre-pack also you want to do this only. In pre-pack, the idea was, let them file voluntarily, let bankers agree informally, then go to NCLT, and there should be a discharge of personal debt of promoter also. Otherwise, you will not have a logical resolution to the entire thing. Agreed with you, sir.
So, on that note, we are all awaiting the amendment bill. And now I would like to invite C. Amit Churaria to deliver formal vote of thanks.
Thank you, Rashmi. Respected dignitaries, seniors, and professional colleagues, I, C. Amit Churaria, on behalf of ICAI, have the privilege to propose this vote of thanks at the conclusion of this insightful IBC 4.0 session. Our sincere gratitude to CA Vishnu Tulsianji, our chairman, for his leadership. Special thanks to CA Hariram Agarwalji and all the other past chairmen present here. We are equally grateful to the past presidents, chairmen, and council members who are present and whose wisdoms have guided us all through. I extend my heartfelt thanks to our coordinators, to our coordinator Rashmi ji, for her flawless organizing this session. Our sincere appreciation also goes to our speaker Tania ji, partner India Law LLP, and Sri S. Badri Narayan ji, who is an expert IP, for sharing their valuable insights. Thanks to all our participants and members for their enthusiastic engagement, which has made this session truly meaningful. With that, I bring this session to a close, taking forward fresh learning and renewed commitment to our professional role under IBC. Thank you. Thanks a lot.